Hey, Nero,
Right.
do you need me on the video yet?
Yes, you can switch on your video.
Is it okay?
Yep. Okay. Hold on. Let me just give me a second. Just need to. All right. Yeah. Good evening, everyone. Thank you for attending today's webinar. Sorry, can you see the slide? Yep. Okay. All right. Sorry for the technical issue.
Okay, you need a bit of practice. Not quite.
Yeah.
I don't know how many times I've done a rehearsal on this.
Okay, all right. We shall start our webinar. Thank you, everyone, for attending today's webinar. Today's webinar is organized by CIArb Qatar branch. My name is Nurul Sabri, and I'll be the host for today's event. So just a bit of a background about myself. I'm a senior consultant with HKA based in Doha, Qatar. I'm also one of the CIArb Qatar branch board member. So today's webinar topic is arbitration, persuading the tribunal. So we have Win Clark as a speaker. Before I introduce the speaker, just a brief overview of our Qatar branch, CIArb Qatar branch. So the Qatar branch was officially opened in February 2018. So the branch have established a close working relationship with the Qatar International Court and Dispute Resolution Center, QIC-DRC, since 2017, with whom we have signed an MOU. So together with QIC-DRC, the branch is keen to further promote education and training on arbitration and ADRs within the state of Qatar. I would also like to take this opportunity to thank QIC-DRC and its CEO Faisal Rashid Al Sahuti for their continuous support. Currently, we have a total of 14 board members with 215 local members. We welcome individuals from all backgrounds who have interest in ADR to join CIArb as a member. So this is today's agenda. We will start with the presentation and then followed by Q&A and a closing remark by Mr. Ahmad Al-Ansari, the CIArb Qatar branch president. So now a bit of background about our speaker today. Our speaker, Wayne. Wayne is a chartered quantity surveyor, arbitrator, and mediator with over 50 years of international experience. He is currently based in Lausanne, Switzerland. He has worked in Africa, UK, Europe, Asia, and the Middle East. Specifically, Wayne has spent 10 years in Qatar, mostly working with HKA, previously Hill International, before moving to Switzerland. For the past 40 years, Wayne has focused on contract dispute and risk management, primarily dispute avoidance. Wayne has been appointed as arbitrator, career 8 times, mediator, and expert witness on various international construction dispute. Wayne also advises third-party funders on the merits of potential client arbitration cases. And as a result of his appointment as arbitrator, Wayne has also acted as shadow arbitrator, providing feedback to legal counsel and clients on how best to persuade a tribunal, hence the topic of today's webinar. Wayne has lectured at universities in Hong Kong and South Africa, presented conference, seminar papers, run in-house workshops and training programs for organization, and has had articles published in construction journals. Very impressive profile. So, all right. Okay, before I pass the floor to Wayne to start the presentation, just a bit of housekeeping. So if you have, if anyone have any questions throughout the presentation, please feel free to post it on the Q&A box at the bottom of the screen. We will aim to answer all questions towards the end of the presentation. We will also be sharing the presentation slides to all attendees after the webinar. Okay, Wayne, over to you.
Okay. Good evening, everybody. It's really good to be back in Doha, even if only virtually. I miss you guys. As Nero said, I was working in Qatar for 10 years, and yeah, it was a very good time I had. And my sincere thanks to the CIArb, Qatar and QFC branch committees for inviting me to make this presentation. And a special thank you to Nero for making this webinar happen and for her flattering introduction. Very much appreciated. Thank you. This presentation, Arbitration to Persuade the Tribunal, is based on my personal experience of arbitration in various parts of the world. It is also based to some degree on my book that is about to be published. I'll introduce you to my book a little bit later. As some of you may know, I've been involved in the construction business for quite a long time, 55 years to be precise, if my fading memory serves me correctly. And during this time, I've noticed that arbitrations are often the result of disputed claims, claims that have not persuaded the other side, claims that for various reasons could not be settled by negotiation or by ADR procedures such as mediation. Having said that, arbitrations are sometimes triggered much earlier. Arbitrations are often the result of projects in trouble because of poor management by the employer or its team, poor management by contractors, or poor management by subcontractors. So in the first part of this evening's webinar, I will touch briefly on projects in trouble and disputed claims, why these can create conflict, and why these can end up in arbitration. I will then discuss the approach and strategy when preparing for arbitration, when arbitration is the only means left for a final resolution, the approach and strategy that can persuade a tribunal. Could we have the first slide, please? Nero, can we have the first slide, please?
We may have a slight technical problem. Are you there, Nurul?
Hi, yeah, sorry, apologize. I think I have some
Share the slides, please. On the screen.
technical issue here. Yeah, just a moment.
Yeah.
Okay, can you see the screen, the slide?
Right, yeah, if you could go up to the top.
Top, hold on, just a second.
Okay, that's fine. That's the start. Thank you very much. So this evening's presentation, we will look at the root cause of many construction arbitrations, which, as I just mentioned, will be projects in trouble and disputed claims. Having tried but failed to resolve the differences through negotiations or ADR procedures such as mediation, the parties will have little option but to resort to arbitration. The focus of this evening's presentation, arbitration, persuading the tribunal. Three aspects of arbitration I've chosen to highlight tonight are the investigation, the submissions, and the hearing. And before closing this evening's discussion, I will introduce you to the shadow arbitrator. Next slide, please. Projects in trouble, a recipe for disputes, sometimes a recipe for disaster. Trouble often begins in any one of, or not all, the following stages in our construction projects. Employer's concept planning, preparation, and project document stage, the contractor's planning, program, and resourcing stage, performance by the employer, the contractor, and also the subcontractor, and contract administration, contract management. These stages, go back please. These stages, if not well managed, are all ingredients for trouble, ingredients for delays, for budget overruns, claims, disputes, and eventually arbitration. Okay, next slide, please. So let's look briefly at these stages. The first one, the employer's concept planning and preparation of project documents. Trouble is often born at the employer's concept and planning stage, rushing to start without adequate planning and preparation, such as failing to obtain planning permission, not having acquired sufficient land, and quite common problem, failing to give the professional team sufficient time to develop accurate and complete project documents, both for tendering and for executing the works. Inadequate budget, quite a common problem. And choosing or amending the contract to impose disproportionate risks on the contractor. And not providing sufficient time for the contractor to execute the works, and then imposing severe delay damages on the contractor for failing to meet these unrealistic contractual milestones. So before we move on to the next, I have an example of a project in trouble when they rushed to start. Not enough time was allowed for the professional team to prepare adequate and complete documents. Again, there was insufficient budget, and the contract that was chosen by the employer was an EPC turnkey contract with all the risks being allocated to the contractor. The tenders were all hugely above budget. Panic stations, what to do? And urgent meetings with the team, the architect, the engineer, the quantity surveyor. Shrink some of the areas of the building, reduce the floor to ceiling heights, save money, change the concept, change the contract from a build only to a build only from the turnkey project. Reallocate the risks. The employer will take over most of the risks. The tender prices will be lower. There was a rush to convert the drawings, to rewrite the contract, and to re-tender. It worked. The tenders were all within budget. There was relief all round. However, the trouble had just begun. Because of the rush, there were insufficient drawings to start the work. The revised drawings did not work. They had to revert to the original drawings in some areas and revert to the original ceiling, floor to ceiling heights. This all resulted in late changes, late variations, additional costs, delays, claims, and disputes. The project completed 2 years late and 3 times over budget. The dispute took years to settle, all by arbitration and some in the courts. Okay, next slide, please. Contractors tender, planning, programming, and resourcing stage. Getting the price wrong at the tender stage. Sometimes the contractors deliberately underpriced to win the project, relying on claims to recover any shortfalls. This seldom works. Lack of planning at the early construction stage. Assembling the wrong team, in particular the contractor's management team. Not understanding the contractual obligations and procedures, as well as not being aware of the risks that have been imposed on the contractor under the contract. Poor programming and resourcing, with construction managers and the planners not working together, not cooperating. On a project I worked on in the Middle East, the planners prepared the program and the resources totally alone. There was no input from the construction managers, no input from the people who were aware of the resources that are needed for specific works, who could gauge the durations needed for these works. When planners are alone prepare the program and resources, to me, this is the tail wagging the dog. It doesn't work. In this particular case, the program and the resources were unrealistic. They simply did not work. The result, delays, budget overruns, claims, and disputes. The project ended in trouble. Conversely, in another case in Asia, similar circumstances, planners dictated the program. It was unrealistic. However, the construction managers recognized this, ignored the programs, filed them away to gather dust, and prepared their own programs. They worked. That project did not end in trouble. Lack of planning by the contractor or the subcontractor at the outset of a project can and often does lead to claims, disputes, and ultimately to arbitration. Next slide, please. Poor performance during the construction stage. A few simple examples include poor performance by the employer, failing to issue change and variation orders in good time, late approvals, drawings, materials, suppliers, subcontractors, etc. Now, I've no doubt that the many contractors that are here this evening can quote several more examples of poor performance by the employer or the employer's representatives. And then we look at poor performance by the contractor, delaying starting works, inadequate resources, lack of monitoring both progress and budget, poor progress, unjustified delays. And again, I know there's no doubt that the employers here this evening can quote many, many more examples of contractors for performance. Next slide, please. Poor contract administration, contract management. Typical examples of poor contract administration by the employer and or the employer's representatives, the engineer or the project manager, whoever, undervaluing completed works and making late payments. Unreasonable valuations, rejection of contractors' claims or their variations. Rejection by some employers' representatives, sometimes the result of pressure from the employer, sometimes the representatives themselves simply abusing their authority. It happens, fortunately, not that often in my experience. However, there was one particular project that I worked on where the representative did actually abuse his authority. The contractor submitted a claim that was clear, concise, based on the facts, and fully supported by the evidence, fully supported by the records. It was rejected by the representative. He sent a long letter in excess of 20 pages explaining that the claim was rejected because it was unsupported. There were no records, there was no evidence. It was quite clear that he had not seen the evidence or had not bothered to look at the evidence. And this became more apparent during numerous negotiations. He simply repeated his position over and over again. Your claims were not supported. After months of attempting to persuade him to look at the evidence, which it had for several months, he ignored. The contractor, frustrated, filed for a notice of dispute. This alerted the employer of trouble. Until then, the employer had been advised that there had been no grounds for a claim. A meeting was eventually arranged between the parties' senior management without that particular representative present. After several meetings, over a few months, the matters were finally settled. The contractor received a reasonable extension of time and costs. I'm told that that particular representative was replaced and he had abused his authority once too often. So then we have delay in taking over the works by the employer. This is a tactic that is used by some employers to avoid having to maintain the facility after it's been handed over and to avoid having to return the retention money to the contractor, which is sometimes quite significant. And some typical examples of poor contract administration by the contractor we see time and time again: late or no notices of claims, a common failure by contractors and subcontractors, unrealistic or exaggerated claims and variation values, also a common occurrence, poor record keeping, a serious weakness by many contractors and subcontractors, and deliberate underpayment of subcontractors by the main contractors. And this impacts on the subcontractor's performance. I'm aware of at least 2 arbitrations in which underpayment was a serious, major issue. Okay, next slide, please. Having dealt briefly with projects in trouble, we will now move on to disputed claims, failed settlements. Typical causes of projects ending in arbitration, certainly from my own experience, include rejected claims, disputed values, failed settlement negotiations, and unsuccessful attempts to resolve disputes through the ADR process procedures. Okay, next one, please. So a quick look at some of the reasons for rejected claims and disputed values. Unsupported claims. When claims are based on perceived or not actual facts, they will be rejected. Lack of records, lack of evidence, a very common failure. The evidence, the records are essential. Without supporting evidence, claims will most certainly fail. unrealistic expectations such as money, exaggerated money claims, quite common in my experience. I know of some contractors who deliberately inflate the values of their claims in the hope of achieving what they want, what they need during the negotiations. This seldom works. And as we discussed earlier under the contract administration, unreasonable valuations by the employer's representatives or by the main contractor when assessing subcontractors' claims. Rejected claims and unreasonable valuations are all ingredients for conflict and inevitably for arbitration. Okay, next please. Failed settlement negotiations. Why do negotiations fail? In my experience, mainly because of entrenched positions. When one of the parties, sometimes both, but usually one, seeks total victory, no compromise. Compromise is often considered as a dirty word, but for me, it's necessary sometimes to settle. It's necessary to find a sensible solution. They fail because of no interest in other parties' positions, only interested in demolishing the other side's case, and no concern for future relationships. Extremely short-sighted, in my opinion. The above approach, the above technique is known in the negotiation world as positional bargaining. I call it bullying tactics. They seldom work and usually ends up in the next stage, mandatory ADR proceedings. Next, please. Unsuccessful attempts to resolve disputes through the ADR process. Many construction contracts these days stipulate mandatory dispute resolution procedures before the parties can enter into arbitration or to refer their disputes to the courts. Mandatory resolution procedures such as mediation, which is quite common in many international construction contracts. The problem I have with mandatory mediation is that one or both parties will simply go through the motions with no interest at all to settle, no interest in finding a sensible solution. For mediation to work, in my opinion, it must be voluntary. Both sides must want to settle. Otherwise, mediation can be a waste of everybody's time. And there was one occasion when I acted as a mediator, it was quite clear that one of the parties had no intention to settle. And it was a waste of everybody's time in the end. Okay, next one, please. So having failed to successfully manage the project by either side, by either the employer or the contractors, having failed to agree the contractors or the subcontractors' claims, and having failed to find a solution through negotiation or through mediation, through ADR, the inevitable result will be arbitration. In this discussion, Arbitration Persuading the Tribunal, we will be looking at the investigation, preparing our case, drafting key submissions, and the hearing. Next, please. Before putting pen to paper, before starting to write a submission, an essential aspect of arbitration for legal counsel and their support team is the investigation. The investigation includes, among other things, understanding key contract provisions, in particular, the parties' obligations and the procedures to be followed. We need to check, or legal counsel needs to check, that their client has met its obligations and has complied with all the requisite procedures. Then investigate the issues, research the issues, research the events, the what, the why, and the when. What happened, when it happened, and why it happened. Who is responsible? Who is liable for the event? And if we research carefully enough, we may even find that it's our own client who is liable. But then we need to deal with it. Analyze the impact of the events on the performance, on disruption, on progress, the delays, and on the contract price itself. And then there's the records, the evidence, vitally important. Search for and find the records that will support our case. To succeed, our case must be based on the facts and must be supported by the evidence, by the records. And from our investigations, from our findings, we can then develop a strategy to persuade the tribunal. We will have identified the strengths and the weaknesses of our client's case. And from that, we can develop a structure for submissions, the focus being on the strengths. And then we must also need to prepare a strategy for our weaknesses. This is vitally important. Our weaknesses will be the other side's strengths. Do not ever ignore our weaknesses. Next, please. There will be and usually are several exchanges of documents in the arbitration process, but the three important documents, the key submissions are, in my opinion, the statement of claim, the statement of defense and counterclaim, and the reply to the counterclaim. The whole story, each party's whole case for persuading the tribunal will be, should be found in these three key submissions. Next, please. Having completed our investigations, having developed our strategy, we are now in a position to prepare our case. So what will persuade the tribunal? What do arbitrators expect from the parties, from legal counsel, for them to be persuaded? To persuade the tribunal, speaking for myself as an arbitrator, all submissions must, at the very least, be comprehensive but concise. Keep the narrative short. They must be clear, easy to understand. We must hold the tribunal's attention from the beginning until the end. Be objective and respectful. Be credible based on the facts supported by the evidence, and be realistic. In particular, be realistic when it comes to requesting relief for money. Next, please. The tribunal will not be persuaded if the submissions are confusing or full of complex technical and legal jargon. If they are long-winded and repetitive, the tribunal may become bored and lose interest, and we don't want them to lose interest in our case. They won't be persuaded if the submissions are emotional, disrespectful, or confrontation. A bad idea. And if they contain unsupported arguments and statements, or if they're based on perceived or alternative facts. Alternative facts, you may ask, where does this come from? Well, alternative facts was accredited to a lady by the name of Kellyanne Conway. She was an advisor to Donald Trump. In an interview during the Trump campaign, she explained how she viewed Hillary Clinton's statements. She maintained that these statements were alternative facts and not actual facts. In other words, they were rubbish. This phrase was also used by a Greek client of mine when he was describing the other party's argument statements relating to matters in dispute. He said, all my client statements were actual facts. The other party's arguments were all alternative facts. Next, please. Supporting documents, the evidence. I labor this point, but it's slightly important. Every statement, every argument we make in our submissions must be supported by the actual facts, by the evidence. And these records, the evidence, the records will be contained in the exhibits that accompany the submissions, that accompany the story. In cross-referencing the statements in the narrative, statements in the story, to the evidence, to the exhibits is absolutely essential. The case in my early days as arbitration, the claimants submitted exhibits that were contained in several large leverage files. There were no divisions, no subdivisions, no numbering of the exhibits. Just one page or hundreds of pages with no links. The statement of claim made no reference, or made a reference only to as supported by the attached exhibits. No reference was made to any numbers. No reference was made to any exhibits because there were no numbers. As presented, it was impossible for the members of the tribunal to locate the supporting documents. I myself spent several hours, days, in separating and tagging each exhibit and then referring back to a statement of claim to link the exhibits to the arguments. Well, it was my very early case as an arbitrator. and I was naive. In hindsight, we should have returned the files to the claimant and demanded resubmission in a more professional way. Make it easy for the tribunal to find the evidence. Having exchanged submissions, witness statements, reports, and all other documents, we now enter into the final phase of the arbitration, the hearing. During the hearing, the tribunal will be listening closely to and may very well be persuaded by the opening statements, the witnesses, and the closing statements. Next, please. The opening statements are the executive summary of the submissions. They emphasize the key aspects, the strengths of our case. They should be concise, kept short, and be convincing. I was involved in arbitration not so long ago when the tribunal and the parties all agreed that the hearing was to be completed in 1 8-hour day. Each party would be allocated 4 hours to present their case, with opening statements, witness testimonies, cross-examination, and closing statements. Counsel for the claimant took up almost all of his 4-hour allocation in his opening statement. He insisted on reading the statement of claim word for word, ignoring the chairman's repeated reminders that one was the tribunal had read the parties' submissions, they had read the statement of claim, and 2, that the counsel needed to keep the statement short. Counsel continued to drone on, reading the entire statement from beginning to the end. Apart from annoying the tribunal and his client, he missed a golden opportunity to highlight the strengths of his client's case. He missed the chance of making a good first impression on the tribunal. The opening statement will leave an impression on the tribunal, good or bad. The legal counsel in the case I just mentioned did not leave a very good impression on the tribunal. As quoted by Professor Rees, who we will meet very soon, first impressions count. Next, please. Witnesses. I'm referring here to witnesses of fact, or fact witnesses as sometimes called. Usually employees of the party, often construction managers having first-hand knowledge of the project. Counsel should avoid trying to discredit the other side's witnesses when cross-examined. The tribunal will not be impressed. And most counsels will no doubt deny ever having coached their witnesses before a hearing. But we know they do. So counsels, when coaching the witnesses, ensure that they tell the truth, or at least avoid telling lies. The tribunal will know when the witnesses are not telling the whole truth or simply towing the party line. Witnesses play an important role in persuading the tribunal, particularly when they are telling the truth. Witnesses who are not being totally honest will also persuade the tribunal, but not in the way they or their employers will be happy with. Next, please. Closing statements given orally at the end of the hearing should be no more than a very brief summary of our case, reinforced only with any positive revelations that appear during the hearing, either from the witnesses or from the experts if they exist. Post-hearing briefs are sometimes preferred by a tribunal, especially when the hearing has lasted several days. Post-hearing briefs are another executive summary. As for the opening statements, they should be clear and comprehensive but concise. The closing statements and the post-hearing briefs must also leave a good impression on the tribunal. Now, Professor Rees again, first impressions count, opening statement, last impressions stay, closing statement. Next, please. I will now introduce you to the shadow arbitrator and also to Professor Rees. I first discovered the shadow arbitrator in an article in the Swiss Arbitration Association Bulletin that was written by Professor Dr. Jörg Rees, who is a partner with Baker McKenzie based in Hamburg. His article was entitled "The Shadow Arbitrator, a Mere Luxury or a Real Need?" In his article, he explains the shadow arbitrator's function. The core concept of a shadow arbitrator is to help a party and his counsel to better understand how a tribunal is likely to perceive and assess a single submission or the entire case. Next, please. So what are the advantages of using shadow arbitrator? As a practicing arbitrator, the shadow arbitrator understands what the tribunal is looking for, understands what will persuade the tribunal, has an unbiased view of the case. We can help our client and legal counsel prepare a convincing, a persuasive case. Understands how the tribunal reads submissions, how the tribunal listens to the pleadings and to the witnesses, and understands how the tribunal deliberates when preparing the award. If engaged early in the process, the shadow arbitrator will be a wise investment, according to Professor Rees. And naturally, I agree wholeheartedly with Professor Rees. Okay, so a quick recap on this evening's presentation. We looked at the root cause of many arbitrations: projects in trouble due to less than satisfactory management by employer and or by the contractor, and disputed claims not being able to find a sensible solution. We then discussed arbitration persuading the tribunal, the investigation, essential before putting pen to paper, before starting to develop our case, and then preparing our case, the written statement to be clear, concise, based on facts supported by the evidence. In the hearing, don't bully the witnesses, let them tell the truth. Opening and closing statements, first impressions count, last impressions stay. And finally, the shadow arbitrator, a wise investment. Next, please. Next, please. And now we wait for the award. How confident are we? Have we persuaded the tribunal? Only time will tell. Thank you. That's all from me for now.
Thank you, Wayne, for the very comprehensive presentation. We have one last slide, so I'm not sure whether you want to mention it now or you want to mention it later about what you mentioned.
Now, get it out the way. Okay.
Hold on, let me just. Yep.
I mentioned in my introduction about my book. It's about to be published. As you can see, the book is going to be called Construction Disputes: Seeking Sensible Solutions. The publishers are London Publishing Partnership. Just a brief outline of the contents. What this book actually talks about is in 9 chapters, short chapters. It's not a long book, but we discuss managing construction projects to prevent disputes. We discuss wise contract and claim management, and construction claims, the investigation, similar to the investigation we talked about in preparing our case for arbitration. I also have a short chapter on COVID-19 pandemic, and then a long chapter on preparing claims to persuade a tribunal. And then the next chapter is seeking that sensible solution, the negotiation process. And then when negotiations fail, alternative dispute resolution. And I discuss mainly mediation and dispute courts. And then finally, when all attempts to settle fail, arbitration. So that's the general summary of my book. It should be published, I'm told by the publishers, hopefully the beginning of next month. And the bottom of the page there, we've got the publisher's website, and I'm sure in good time they'll be sending out information about the book and how it can be purchased. Oh, Muriel, I'm happy now to answer questions on my presentation and on my book.
Yep. Okay. Thanks, Wayne, for the comprehensive presentation, and I'm really looking forward for your book. Hopefully, it will be published next month. So, okay, yeah, we're moving on to the Q&A. So we have a few questions. Let me stop sharing the screen first. Okay, we have a few questions. Okay, the first one. Okay, the first one with, in the absence of sufficient supporting record, how likely global claims can be considered by a tribunal?
Please say it again, I didn't quite follow.
Okay, in the absence of sufficient supporting record, how likely global claims can be considered by a tribunal? So
How likely will global claims be considered by a tribunal?
Yeah, so basically will global claims be considered by a tribunal?
Right, yeah. Well, I mean, all claims will be considered by a tribunal. And it depends on how global, if you like, the global claim is. But basically what parties need to do, particularly claimants, they've got a claim, they have to demonstrate the cause and effect of the various events that are included in the claim that have caused the problems. Now, global claims, as far as I understand them, are sort of general. They don't identify any specific events that created the problem, that created the delays. It just list of all items that happened, but not analyzed. And that becomes a bit of a problem. It'll depend on how the other party, say the respondent, deals with the global claim submitted by a claimant. If the respondent has done an analysis on the various events that took place that caused the problem and can demonstrate the responsibility of the parties, the liability of which party, but the claimant with his global claim cannot do that, then the tribunal can have difficulty in accepting the claimant's global claim when the opposition can demonstrate in more detail the cause and effect of each individual event that caused the overall delays. So I'm not suggesting that the tribunal will dismiss the global claim. It depends on how it's been presented, what information is available, and what the other side comes up with. Now, I did hear about one particular arbitration where the claimant prepared a disruption claim based on a formula, based on some difficult to understand scenario, but came up with the answers that came up was that the claimant, the contractor, admitted or accepted 40% of the impact of the disruption. Was claiming 60% of the cost. The respondent, the employer, maintained that the contractor was liable for all the disruption issues, but never presented sufficient information to prove what he was saying. So even though the tribunal may not have understood the complex formula that was used by the claimant, the fact that the claimant was prepared to accept a portion of the blame, the tribunal awarded in their favor, and they got 60% of the request. And there again, the respondent never came up with any detail to counter what the claimant was claiming. So it's difficult to answer generally because we need to see what the evidence is. We need to see the submissions and how they were supported, what they're supported by. If there's no support on a global claim, it's going to be very difficult for a tribunal to award in favor of the claimant. I hope that answers your question, and I know it's probably not what you want to hear, and it's a bit vague, but it has to be vague because we need to see what it looks like.
Yep. Okay. All right. Thanks, Wayne. So the next question, why can't the response to the reply to the statement of defense be a source of info to the tribunal?
Why can't the what? Sorry,
why can't the response to the reply, why can't the response to reply to the statement of defense be a source of info to the tribunal?
Struggling to hear this, understand. Sorry, the question.
I don't quite understand the questions actually. So, okay, the questions ask, why can't the response to the reply to the statement of defense be a source of info to the tribunal?
Sort of what for the tribunal?
Source of information to the tribunal.
We're talking here about the claimant's, the respondent's reply
To the
I think it's probably the responding statement from the respondent to the claimant statement.
Say again, sorry.
I'm not too sure. Do we have Karim with us? Maybe you can unmute him to maybe ask the question.
Yeah,
Karim, can you unmute him, Nurul?
yeah, Karim is here. I'm not sure whether he's able to speak.
Maybe you could write it down.
Yeah, do you want
Yeah.
rewrite that question, Karim, please?
Yeah, please, Karim. Yeah. Okay. Okay, while we're waiting for Karim to rewrite the question, so we'll just go to the next one. The next question, we'll come back to Karim once he posts the questions again.
Sure.
So the next one, does the place of arbitration has any impact in the award? For example, the dispute occurred in Qatar and the arbitration takes place in France as per the conditions outlined in the contract. So the question is, does the governing law of France will be considered for the award, or will it be restricted to Qatari law?
Okay. The law governing the seat of the arbitration will govern the procedure of the arbitration. It will not get involved with the issues with the case. If the contract was in Qatar and the governing law of the contract was Qatari law, then Qatari law would dictate the tribunal's decisions on the events of the case, the issues relating to the disputes relating to the case. So they are separate, but the French law will not influence the decision of the tribunal based on the facts, based on the issues and the arguments. Qatari law will. Does that answer your question, sir?
Yep, hopefully we'll answer the questions. Okay, yeah, okay, all right, thank you. So we'll move to the next one. Okay, okay, back to root cause of trouble. What are the chances of dispute emergence due to wrong building of procurement strategy and selection of procurement method?
You have to say it again slowly.
Okay, what are the chances of disputes emerge due to wrong building of procurement strategy and selection of procurement method? What are the chances of the disputes occurred due to the wrong building of procurement strategy and selection of procurement method?
The wrong what of documents?
So
the wrong procurement strategy and selection of procurement.
The question is, sorry, Nurul, what are the chances for emergence of disputes in case of considering wrong procurement method?
Wrong procurement method.
Yeah, say for example, for a job which may be best to go for design bid build, and we decide to go for design and build, or the other way around. You know, considering the ecosystem here in Qatar, for instance, a lack of sometimes expertise in particular type of procurement methods. But we, as a SGAL, for instance, recently we went for some procurement methods which proven to be too difficult to manage and administer due to lack of resources, lack of knowledge and expertise. So it was very obvious that we had to face lots of difficulties in managing that type of contract, in which resulted in many disputes over design, for instance. I mean, it's by tradition, the client, the employer here wants to dictate design. So how on earth you go for a design and build when the employer controls the design? It doesn't work, doesn't it?
Yeah, I think the important aspect there, if I understand the question correctly, is the evaluation of the tender. So if we go out to tender on a design and build, maybe before we do that, to check that the tenderers, the bidders, are actually capable of design. Have they got the expertise to do that? And this should be done in the first stage of the tendering process. If there's no time to do that, when the bids come in, if the preferred bidder or the preferred bidders should be, they should be looked into to establish whether they do have the expertise. And if a particular contractor is awarded a contract without those expertise, then that's going to, as you said, it's going to create a severe problem. So it's really up to the employer, if it's a main contractor, or the main contractor, if it's a subcontractor, to make sure that they're satisfied that that party has got the capability of performing the job. If they don't check, and that's got to be done right up at the beginning, before the contract is awarded. Otherwise, you're going to have the problems that you have. The contractor will not be able to perform, and there'll be claims and disputes and probably a termination in the end, and then arbitration or the courts. So to avoid conflict, to avoid potential disputes, you need to understand that the employer or the main contractor needs to be very careful, very vigilant in assessing the bids. I hope that answers the question, if I understood the question correctly.
Yeah, I think that was a good answer. Yeah.
Okay.
Next one, Ron.
Yeah, okay. So I think because of the time constraints, so I think we'll just accept one question. So one more question. So Karim provided clarification to his earlier question. So his questions ask basically, why can't the respondent's rejoinder, the response to the reply to the statement of defense, help assist the tribunal in understanding the dispute?
Why can't the rejoinder?
Yeah, why can't? Yeah.
I don't understand, because if we just run through the procedure, we have the statement of claim, we have the statement of defense and counterclaim, then the claimant will then reply to the counterclaim, and then the respondent and the rejoinder will reply to the claimant's reply. And that's quite common. I mean, I selected three statements, three documents: statement of claim, statement of defense and counterclaim, and reply to the counterclaim. In my opinion, those three should be enough, but normally what happens is that the respondent has an opportunity of replying to the claimant's response to the counterclaim, which will be the rejoinder. And the tribunal will take notice of that. There's no question.
Yeah, so basically the tribunal will use all submissions, in order to understand the disputes, correct?
Correct, yeah.
Yeah.
Everybody should be given the opportunity to put their case. And if the respondent feels he needs to add to what's been submitted so far by way of an rejoinder, then they're entitled to do that. But what normally happens in the beginning of the process, in the case management conference, the parties and the tribunal will sit down and agree on the procedural timetable and what documents will be submitted. And at that stage, it will be agreed, for example, that there will be a rejoinder. And then all those documents, all those submissions will be taken into consideration by the tribunal.
Yep, okay. Thanks, Wayne. I hope that answers your questions, Karim. So, okay, unfortunately, due to time constraint, we will not be able to take any more questions. But as we mentioned earlier, so if you have any other questions after this webinar, so please feel free to email it directly to Wayne. Yeah. Okay.
Quite happy for that.
I'll be sharing the presentation slide as well to all the attendees. So before we end our session, so I would like to invite Ahmad Al-Ansari, the president of CIArb Qatar branch, to give his closing remark. Over to you, Ahmad.
Thanks, Nurul. I would like to thank all attendees for attending this important talk by Wayne. Wayne and I have been working together for some time, and enjoyed collaborating with him through the CIArb. He used to be a board member with us, and we're really too happy to see him back joining us in one of our prestigious events. And I wish to keep in contact with you, Wayne, all the time, and we'll be happy to host you in March next year when we will go for our annual general meeting. We haven't yet decided the date, but it will be an honor to host you with us then. One point I would like to make here about this topic of tonight's talk. Many contractors, unfortunately, may think that they would fascinate or impress the tribunal, in our case the employer, by submitting as much documents as possible. When it comes to claims, I, for example, been through this, contractors come to me with this much pile of papers in an attempt to persuade me to accept their claims. So that should not be the case, as Wayne indicated very clearly and expressly in his talk, that it has to be very concise, straightforward, to the point, and solid evidences, not just piles and piles of perhaps wasteful paper. Thank you very much for showing up this evening, and we at Chartered Institute of Arbitrators always look forward to seeing you in our future event. So Nurul, if you could just brief our guest tonight on the upcoming events, please. Thank you.
Yeah, sure. Thanks, Ahmad. And before we end the session, so I'll just like to remind everyone that we have our upcoming webinar next month on the 23rd of November. The topic is conflict of interest for expert witnesses in international arbitration by a well-renowned speaker, Julian Bailey. So please do register on the CIArb website. So once again, I would like to convey my thanks to Wayne for his time tonight. So, and also Ahmad Al-Ansari for your closing remark. And we hope, Wayne, we can collaborate again in the future in the next webinar. And
I would like that very much.
Yeah, please do keep in touch and do let us know if you happen to come to Doha.
I will do, for certain.
Yeah. Okay. All right. Okay. Thanks. Thanks, everyone. Good night.
Thank you too. Thank you, everybody.
Good night, everyone.
For attending. Much appreciated.
Thanks.
Bye.